All right, welcome to the Joint Veterans Endorsement interview for judicial candidates. This is going to be for candidates for the North Las Vegas Municipal Court Department 1. At the outset, we'd like to formally recognize and thank our sponsoring organizations for making today's event possible, where the panelists are from Veterans and Politics International, Nevada Veterans Association, and the Armed Forces Chamber USA. We'd also like to extend our sincere appreciation to our additional sponsors and community partners whose support helps ensure a professional, fair, and transparent endorsement process. This is for Saturday, March 7th, 2026. We'd also like to thank some of the various candidates for their sponsorship, additional sponsorship. Judge Jacob Reynolds, Clark County District Court, Department 29. Judge Mary Perry, Clark County District Court, Family Division, Department P as in Paul. Judge Veronica Barisic, Clark County District Court, Department 5. Danielle A. Tarmu, candidate for Clark County District Court Judge, Department 28. And Amanda Pellizzari, Las Vegas Municipal Court, Department 1. We're honored to have all of you with us today. Before we begin the interview, I'd like to let you know what the rules and the format are. First, the panel members will introduce themselves by stating their names and organizations they represent. Next, each candidate will introduce themselves. Please indicate the office you're running for and explain why you are seeking that position, to obtain it or to retain it, whatever you're up for. We will then proceed to the interview portion. Please remember, this is an interview and it is not a debate. Candidates may not ask questions of one another. All responses must be directed to the panel. In the interest of fairness to all participants, we will strictly enforce time limits. Each candidate will have 1 minute and 30 seconds to answer each question. When you have 30 seconds remaining, you'll be shown a sign. I will just reach out and let you know you got 30 seconds left. If the timer goes off, please finish up the statement that you're on quickly and move on. I don't want to actually have to cut anybody off. We haven't had to yet today, but please respect the time limits. When your time's expired, it's time to move on. Panel members will not be permitted to ask follow-up questions directly. It would have to be the next go-around if they get a chance. If you believe your question was not fully answered, please take that into consideration. I'm sorry, that's information for, I need to mark that because that I don't need to tell you guys. After all panel members have completed their questions, each candidate will be given 1 minute to make a closing statement. At that point in time, tell us what you're running for, why we should vote for you, any way that we might be able to reach out, find more information, speak with you, however it may be. And at the conclusion of today's interviews, we will once again recognize and thank all of our sponsors with Veterans and Politics International, Nevada Veterans Association, and Armed Forces Chambers USA, etc. Are there any questions? Okay, then I will begin with my introduction. My name is Bill Carnes. I am here as a representative for Nevada Veterans Association.
Sorry, I'm stuck. I'm Cindy Lake with Veterans in Politics.
They will introduce themselves after we introduce ourselves.
I'm David Farcon with the Armed Forces Chamber.
Hi, I'm TK Crabb with Veterans in Politics.
And I'm Joanna Farcon with the Armed Forces Chamber.
That was good pointing out, David, because last time we just went right into questions and forgot to have that. But yes, go ahead, gentlemen, if you want to start.
Good afternoon. My name is Alexander Henry. I'm running for North Las Vegas Municipal Court, Department 1. I am running because I do believe that I want to help the community from a different platform where I can hold offenders accountable and help restore the community to whole. I do believe in restorative justice and therapeutic justice, and I believe I can, with my training experience, I can bring that to the community.
Good afternoon. I'm Chris Cannon. I'm the sitting judge for North Las Vegas Municipal Court, Department 1. I was appointed the position back in November of 2025 when my predecessor, Judge Chris Lee, retired. At that time, I had just retired about a year ago from being a police officer for the city of North Las Vegas for 26 years. I'd also been a practicing attorney at that time for over 20 years, doing criminal defense, prosecution, employment law, and immigration. During that period of time, the city council themselves reached out to me and asked me if I'd be interested in the appointment. I had received a call from Judge Lee himself, also expressing interest, thinking that I'd be a very good person to come in and take that position based on my years of experience with the city and my dedication and trust in the city. I've been there my whole life. I love North Las Vegas, and I continue to want to serve in that capacity. Thank you.
TK, you get to start us off.
How do you handle people in your courtroom who are emotional, angry, or disrespectful?
If I'm appointed, and that is my courtroom, I do believe in procedural justice as well. And so if people need to vent and to explain their situation or get their emotions off their chest, I am open for that. They can speak as much as they want, up until a certain point, of course. But however, they should have a say in their case.
When people come before my court, it doesn't matter if you're a criminal defendant, a victim, the prosecutor, or the defense. I think everybody comes in with a different perspective. If you're specifically asking about criminal defendants, I understand that everybody appears, especially in criminal court, they can come in very emotional and very angry. And everybody has, like I said before, has a different perspective. I think everybody needs time to express. And I think courts, for the most part, people end up in front of a judge for 30 seconds, 45 seconds. A lot of courts consider people just a number. They look and say city, county versus this person. And I think that hurts the court. I think that hurts justice. And I think everybody has to be examined as a person under the circumstances that they end up in front of the court and treated as a person equally, fairly, and given that time. And just to add to what Alex said, there has to be decorum in there as well. So we can't just let people go on and on. We have to have procedural. We have to have decorum. But I think there is a balance there. And I think people need to be heard, understood, and sympathized with.
Joanna with the Armed Forces Chamber. Municipal courts often handle a large number of traffic cases. How do you ensure each case receives proper attention?
We can do whatever you want. I'm easy. So. In our North Las Vegas Municipal Court, most of our cases outside of I would probably say about 50% are traffic-related cases. Seeing that we have the change where they actually split between traffic becoming, some traffic is criminal, some is civil infraction, I think there is still protections that need to be given to everyone. So if somebody comes in on a registration violation, somebody comes in on an insurance violation, something under 482 that they could face criminal time with, I think it's paramount that their rights have to be protected. We have a public attorney there, and I make sure, regardless if when that person makes their first appearance, that public attorney is appointed to them. And if they need more time to reset the case in order to present a defense or work out a plea agreement or show whatever they have to move the case along, I have no problem moving that in my calendar. I understand there's a need to have judicial efficiency. However, that has to be balanced on a case-by-case basis with everyone. When it comes to the civil infractions, I stress to our prosecutors that even though it is a financial fine and not any chance that anybody'd have any kind of criminal violation or jail time, there still has to be a fair deal offered to them. They have to have everything explained to them so they understand what they're going to enter into if they decide to take a plea deal or if they like to challenge the citation itself.
While I was in the U.S. Navy, I was an electronics technician who most of my duties included preventative maintenance. Preventative maintenance required us to have forethought in prepping and planning. And so to make sure that the court is running efficiently, I do believe that you have to prep as much as possible to ensure that everything runs smoothly. Thank you.
Thank you.
Bill Carnes for Nevada Veterans Association. What is more important to you if you're sitting as a judge, the letter of the law or the intent of the law? And if you want to find the intent of the law, where would you seek it out?
So if I was a judge, it is first what the law is. And if there's any ambiguity, then we look into the intent. And then you go to the legislative history, maybe secondary sources as well. But primarily, you go to the plain language meaning of the law and you apply it as such. Thank you.
As a judge, I agree with Alex 100%. I think you look at the letter of the law to understand what the law requires, understand what the provisions, if there's any exceptions, or are there any presumptions. A quick example, sometimes there's presumptions that are given under workers' comp law, and that is where you begin your examination there. If there's any confusion outside of the letter law, as Alex said, you do refer back to legislative intent. You can look back to what the legislators, when they passed that law, what was debated, what was meant, what did they want to convey when they created that law. Additionally, as he also mentioned, secondary sources, I think it's extremely pervasive to look at prior cases, especially in Clark County. Why there's a million cases that come in front of different judges of jurisdictions, a lot of the time, especially in criminal law, there is overlap. So what happened in Henderson? What has happened in Las Vegas in regards to this? If there is an ambiguity, look to there. That doesn't have to totally control your decision, but it can give you some guidance. Also have these cases been in front of district court? And if so, do we show deference to district court? I think all of that kind of gives you the guidance in looking at the letter of the law and how it's applied.
Cindy Lake with Veterans in Politics. Do you guys have specialty courts in North Las Vegas? I didn't look into that. Yes, you do. Okay. So if you do, since you do have specialty courts, do you refer a certain number of cases to specialty court? How are those specialty courts working? And would you add any, do you see a need to add any more or different specialty courts based on perhaps the state of current state of violent offenses or domestic violence cases, drug cases, et cetera? Do you think there's a need for more for more specialty courts? And how are those working? And what's your view on that? We'll start with you, Judge.
In North Las Vegas, Department 1 is all our diversionary courts or specialty courts. Department 2 doesn't handle any of those. It's all in my court. We have a veterans court. We have a mental health court. We have also a drug and alcohol abuse court. So there's 4 divisions there. We call them care courts. And within that, we have specialized people that are addressing each of those court cases and the caseload that comes. When we receive a case or a criminal defendant becomes before us, usually what we try to do is determine whether or not that person would be a very good applicant or person for the courts. One of the first questions I always ask is if that person is a veteran. And if so, veterans have special needs. They served our country. So I think they have to get special attention. Also, what we try to do in these specialty courts is determine the reason for the offense. Is it drugs? Is it alcohol? Sometimes with veterans, is it PTSD? Is it a feeling of, when returning from service, are they lost and just have a tough time readjusting back to civilian life? Once we have that, I have weekly meetings with my staff, both the prosecutors and the defendants, and we go through these cases to determine whether or not these diversionary courts would help. I oversee these court cases that come before us, and I personally meet with these defendants on a monthly basis with status checks. We find out how's it going. What do we need to change to make you successful? Do you need housing? Do you need employment? Things like that.
Yes, we need more specialty courts, definitely. That is therapeutic justice. Therapeutic justice is the concept of addressing underlying issues to resolve potential problems and deter future crime while holding defendants accountable. I've been working as a public defender for 9 years, and a lot of what we do is refer people to specialty court. We have veterans court, we have adult drug court, we have mental health court, we have co-occurring disorders court, we have DUI court, and all those courts do help offenders get on track. And I do believe that there is data to show that once somebody graduates one of those programs, recidivism rates drop drastically. And so it is about getting people into those programs and graduating those programs. I believe there's even attorneys in this town that participated in specialty courts, and now they are an attorney because they were able to better their lives. I do believe we need more specialty courts, yes.
Thank you. Thank you. David Farrakhan with the Armed Forces Chamber. How do you explain court procedures so self-represented defendants understand what is happening in their case? We'll start with you, Judge.
Thank you for that question. I think, as I stated before, when a person comes before our court, even if they're not represented, I always want to have the public attorney appointed to them. If that person still does not want to have the public attorney, then I just have them act as shadow counsel and give advice. However, I think it's incumbent upon the court to make sure that that criminal defendant understands what happens if they want to enter a plea and as it goes through the process of that case. So if the person, let's say, appears for a domestic violence case, a lot of the times people just come in and they're like, okay, it's domestic violence, it's a misdemeanor. Okay, I have to go back to work. I don't have time to continue to fight this case. I'll just enter a plea and I'll be on my way. I think it's incumbent upon the court for us to express to that criminal defendant before you enter that plea the consequences. Not only the consequences that happen in criminal court, that you could be incarcerated, you would have to do level 2 domestic violence counseling, you could face a fine, but they have to understand additionally, and I think this is where my experience comes in, that there are other ramifications. They lose their right to have a firearm. They lose their right to have ammunition. They can be arrested for a felony if they're found that. They have to understand that these offenses continue to progress higher, with a second being a misdemeanor, third being a felony. Also, through my immigration experience, I also have to express to them they could be denied naturalization, they could be removed from the country. So, and additionally, beyond that, I think they also have to understand the family law consequences. Domestic violence convictions will keep people from having custody of their kids and could lead to bigger problems in divorce court.
Did you ask whether or not a defendant is representing himself? Could you repeat the question, please?
Absolutely, absolutely. David Farrakhan with the Armed Forces Chamber. How do you explain court procedures so self-represented defendants understand what is happening in their case?
Okay. So before a defendant is representing him or herself, they do need to be canvassed on whether or not they're competent to represent themselves. And so you do have to do the forensic canvass, and you do have to ask a lot of questions to make sure, or to ensure that these people know what they're doing. As far as a judge intervening with the procedures of going forward through a case, I do believe a judge is limited in how much they can help that defendant move forward through the case. Sometimes judges can appoint standby counsel to those people representing themselves to help with the procedural rules going forward.
Very simple. What qualities make a good judge?
Transparency, trust, open communication, listening, compassion, fairness, discernment, integrity, and reliability. Consistency as well.
I would agree with everything Alex stated. That's the problem will come in second. But reliability, consistency, truthfulness. A lot of elected officials get caught up and say one thing and then do something different. I think they have to be held accountable to that. Obviously, knowledge. I feel knowledge of the procedures that happen in the court, knowledge of the law, knowledge of diversionary courts, knowledge of the community that you're serving. And I know you've probably heard it all day, and I'll keep it very, very simple. Transparency. I think the courts should welcome people in there from the public, observers, just people that have no idea what happens in the court. I think that's great. One of the things that I've stressed, and I've put it out in every interview I've done since I've been on the bench, doesn't matter, re-election, city council, whatever. I've invited everybody to come sit next to me on my bench. I have a second chair right next to me. Come sit through criminal arraignments. Come sit through the in-custodies. Come see how we rule. Come see how everything plays out in the court. I think that is the biggest part of transparency that's been missing in a lot of our courts, and I've been trying to add. Thank you. Yeah, exactly.
Joanna Farrakhan from the Armed Forces Chamber. So this is kind of to piggyback off of Chris's comment for the last question. What steps can courts take to make the justice system more accessible to the public? And we'll start with you, Alex.
I do believe that the courts can make, or the judges can make the courts more accessible by engaging with the community, working with community organizations, inviting these organizations to see what's going on, how they can help victims, how they can help defendants, what resources can be provided. And I think that's about it. I mean, I'm sure there's other ideas, but as far as right now, that's what I would think. You would want to have open doors to ensure that anybody can come in and out, see what's going on. It goes to the transparency. It goes to the restorative justice of working with the community, to heal the victims, to also help defendants get on the right track.
I agree once again with Alex's his statements. I think taking it further, as I mentioned, I like that idea that Mr. Carnes put up. It's like judge ride along. I do have a very open bench, and I do encourage everybody to come. Beyond that, I think I've started a program. I'm trying to work with Judge Ketter, my partner in Department 2, to have an open court day at least once a month where we just invite the public and put it out on the city website and say, come in and see how the court works. Come meet your prosecutors, come meet the public attorney, come meet the court clerks, come meet everybody that works in the care team, come meet your judge. Come get to know us. People always think of judges as people that sit up on high benches and they don't interact with everybody. And I think that needs to be broken down, especially at the municipal court level, because this is where most people are going to see the court. Beyond that, I've also proposed, and it's in the process, so it's going to take some time, of also instituting night court. I think night court was one of the ideas that I proposed years ago, but I think it's extremely important because working families and working people give up their right to have their day in court because they can't sacrifice time with their family. They can't miss work. And I think at least 2 to 3 times a month, there should be a night court program. Give these people opportunities to come before the judges, before the prosecutors, before the public defenders, and plead their case and be heard. Instead of taking plea deals, just paying fines, things like that. I think that's how you give access to justice. You give more people more time in that courtroom.
Thank you.
Bill Carnes, Nevada Veterans Association. Thomas Jefferson once stated, that which is legal for the government, but illegal for the citizenry, is tyranny. With that in mind, how do you feel about exceptions to that when it comes to government actions? For instance, police officers who can use their cell phones while driving, or the vehicles that they drive, which are publicly owned, have tint darker than what the law allows for, or driving in the course of the duty and doing otherwise illegal movements in their vehicles without rolling code and signaling those things in advance. Judge, I'll start with you.
As a former police officer, I think I can address this specifically. In regards to the one example you used, the whole idea of using a cell phone, I was never very much in agreement with that. I don't feel that it is fair. I think it's very unfair, to tell you the truth, that if police officers are driving down the road and they're on their phone, and it's not for an emergency purpose, because I know that's the exception to the law. But if they're calling to find out, calling their friends, hey, where are we going to lunch? Hey, what are we doing after duty? That is totally unacceptable to me. Not only are they a distraction, but then they're also as bad as everyone else out on the road that they passed this law for. Additionally, I find that a lot of the exceptions that are given to them have good intent. I understand why the legislature wants to create those, but I think they have bad application. I know for a fact that there are police officers that will come to 4-way stops, turn on their lights, run the light, because not that they're going to a call, but just because It's more expedient. And I don't think that's fair. I don't think that's right. I don't think that's why that law, any of these laws were actually passed. And I think police officers are now being held accountable. When you turn on your lights, your body camera comes on. People are seeing more and more of these offenses happening and reporting them. And police departments, for the most part, and I can only speak for North Las Vegas since I was there, were very proactive in addressing those issues. If a complaint came in that was attached to a video, if a complaint came in from a citizen, that officer would be referred to internal affairs. They could lose their job. They could be suspended.
Well, determining whether or not it's justified under the law or whether or not it's an employee taking advantage of his or his privilege, I think those are two things that need to be separated. If a law enforcement officer is appearing before me as a defendant because he was cited for maybe talking on the phone or running red lights or speeding or crashing, he or she would be treated under the law as anybody else. As far as feelings, of course, I would be a judge, and I want to make sure that I am impartial and applying the law accordingly.
Cindy Lake, Veterans in Politics. Okay, this is a long-winded question on a subject near and dear to my heart. What is your opinion on providing jurors with true and accurate information that fully informs them of their historical right to judge both the facts and the application of the law in a case, a fully informed jury approach, which may include the concept of jury nullification, as opposed to the standard judicially constrained jury instructions used in Nevada courts, where jurors are directed to apply the law solely as declared by the judge without questioning the law's validity or fairness. And I'll append to this a little bit. Rather than just declare by the judge to inform the jury that they can judge the law or the law's constitutionality. I'll start with you, Judge.
I can say in North Las Vegas, the only jury trials we actually have are for domestic violence, and that would be requested by the defendant, obviously, or their counsel. As a judge, I think we're bound to put out the jury instructions that are consistent with the canons and consistent with the law that we have to put out. I think an advisement from the judge that the jurors are more than welcome to consider all evidence that is legally obtained through testimony, through presentment by either side, totally appropriate. I would also tell them, and I have told them, that they have the full right and authority to consider each witness and give them their due weight. If you believe that witness, great. If you don't, then you give them their due weight. So, and I think that comes out in the court through the prosecutor laying out the evidence and the defense attorney laying out his evidence, and then really how the jurors, one by one, consider the evidence presented before them. I think advocating or having a judge get out there and say, hey, there is the option of jury nullification could result in many appeals, and I think it could be problematic. And that's why I'd probably advise against it.
I agree. It's my understanding that the judges, the prosecutors, and the criminal defense attorneys cannot advise the jury members of jury nullification. However, I think that could be a community organization event where they spread the word about what jury nullification is and how it could be applied and how it could be used, whether or not how it could be used, either with good intent or maybe even bad intent. However, like Chris said, if a judge gets involved telling the jurors about this, there could be ramifications where it would be inappropriate, and I'll submit it.
David Farrakhan with the Armed Forces Chamber. How would you ensure sentencing decisions remain consistent and fair in your courtroom?
Okay. For sentencings to be fair and consistent, I do believe that you have to look at each case and apply the law to that case and understand what your sentencing range is for that specific case. Also, you have to take into account arguments by counsel, either on the prosecuting side or the defense side, where there's going to be aggravating circumstances and there's going to be mitigating circumstances. You have to take everything in consideration. You have to look at everything in a holistic approach, and you stay consistent with your own rubric, as lack of better words, to ensure that things are consistent and are being applied fairly.
First off, I love the word rubric. Very nice. In regards to sentencing, I think it's imperative upon the judge when it comes to sentencing is to weigh fairly all, as Alex said, all the factors that are before them. What is the criminal history of the defendant before? What are the facts and circumstances that led this person here? Are they a repeat offender? Have they been through special courts? Have they been through the diversionary programs that could be offered by the courts? That would be almost the intent of a rehabilitation part if you wanted to consider that in the sentencing. Also, I think you have to take in, like also Alex said, the statements that are provided by the defendant. Many times we open it up for, every time actually, we open it up for the defendant to present a statement to the court before sentencing. We also give victims the opportunity to come in and make a statement before sentencing. I think that is also very influential on a sentencing there. However, courts have to be consistent. We have to understand the guidelines that we have and what we can sentence people to. And you have to balance the idea of punishment versus the idea of justice. And you have to understand that giving every single person 6 months in jail isn't always appropriate. Giving everybody 6 months probation is not always appropriate. And so, as Alex said, and I agree with him, it has to be taken on a case-by-case basis, considering all the facts and circumstances that are placed before the court.
TK Crabb, Veterans in Politics. If someone in your courtroom loudly accuses you of being unfair or biased, how would you respond in that moment? And I'll go with you, Judge Cannon.
Thank you for the question. I've actually had this happen. Without going into all the facts and circumstances of the case, I did have a criminal defendant come in and say that I was not being fair. And I tell you the very truth, I was taken aback because you have a gallery of other people, you have court officers, things like that. And while I do stress decorum, I also want to hear from that person. And I specifically addressed them. I said, okay, sir, I understand you don't feel you're being treated fairly here. Specify in me why. Am I not listening to you? Did you not have an opportunity to present evidence? Did you want to go to trial on the case instead of accepting a plea agreement? And really try to flush it out. Because I think if someone feels that they're being treated unfairly in the court, it is the court's duty to try to get to the bottom of that. Because they might not be the only one. They might be one of many of those people in that gallery that have been before you and do think you treat people unfairly. Or maybe you truly are, as the judge, running your court unfairly. And this person was the only one that spoke up. So I think you have to give them the forum there to address that. And also you're going to have to limit it. We can't have an open forum in front of, and put the whole docket on pause while this guy, vents everything out. But if it's something specific that the court can address or we can resolve, I think it is something that we need to do as a court.
I agree with Chris. Let's talk about it. And we can do it one or two ways, either right then and there in front of everybody, and we can have some open dialogue, some open communication, some open transparency as well. And there is another way where we can say, hey, let's trial this case, let everybody get out of court, and then we can talk about it. And you go and you have that route and you try to educate somebody, you try to listen to their concerns, and you work with the attorneys that are there as well. And hopefully you can have this open dialogue so you can build trust and build community relationships.
Joanna Farrakhan with the Armed Forces Chamber. How should courts balance punishment with rehabilitation? Alex?
And I alluded to this earlier with the specialty courts. The specialty courts do exactly that. They are able to address underlying issues and try to rehabilitate people and their issues, whether it's mental health, whether it's substance abuse, whether it's trauma, whether it's just emotional deregulation or unregulation, and while still holding punishment over their head. So if they do mess up, they are going to be punished accordingly. Also, a lot of cases that do come before the judge are already negotiated between the state and the criminal defense attorney. As a judge, I do believe you need to follow negotiations because those attorneys are in the weeds of everything. They know what's going on. They know the ins and outs. They already investigated everything. They had their investigator go out, talk to witnesses. They collected evidence, and they've done the mitigation. They've done the substance abuse evaluations, mental health evaluations. They just have the better understanding of what's going on. And so you would follow the negotiations, and if the negotiation requires somebody being punished in a certain way, you would act accordingly. If it's rehabilitation and they're supposed to participate in the program, you would act accordingly. Thank you.
I think it's a very fine balance. And like Alex was alluding to, and I agree, when these cases come before us, especially in Department 1 where we have so many specialty courts, I think it's incumbent at the very get-go to see if specialty courts can stop the reoffending and address the issues that are there. As I mentioned at the very beginning, is it PTSD? Is it alcohol? Is it drugs? Do they need domestic violence counseling? Things like that. Once criminal defendants are screened by professionals, then usually they enter an agreement between themselves, the public attorney, and the criminal prosecutor. And then they go off into this program, and hopefully we can address the issues that happen there. And I think that's the rehabilitation part. Secondly, if the person is either not suitable because it's a violent offense or they're screened out, and sometimes people just do not want to go into specialty courts, they'd rather just remain in criminal court, then, as Alex mentioned as well, you have the plea agreement that is worked out. While judges do have the ability to go outside of that plea agreement, it's not binding upon them. Unless there's something specific that I feel is needed there, I abide by those plea agreements. And I think the suspended sentences that are placed on people that are hanging over their head when they have to complete all these other requirements is the rehabilitation part. If they do not complete what they agreed to, then they receive due process again, and they could look at a revocation hearing and jail time.
Bill Carnes, Nevada Veterans Association. In your experience in spending time in the North Las Vegas Municipal Court, what is your opinion is the biggest time-wasting offense that people face that maybe should be reconsidered as an offense that's even used by law enforcement, for example? Alex, we'll start with you.
I normally practice downtown in Justice Court and District Court. As far as time-wasting offense, I do see a lot of transient citations that include like loitering, trespassing, things like that. So maybe that would be one of the first ones that come to my mind, right? And as far as the police being able to deal with the situation, I do think Metro is working on that, where they do provide services or they do provide resources up front rather than trespassing somebody or sending somebody or citing them. But other than that, I'm not too familiar with whether or not Metro, how far involved they are with these waste of time offenses. However, there are some that are there, and hopefully Metro could be on the forefront of working with the community and providing alternate routes besides going to court.
I would agree with Alex in regards to homeless issues or the unhoused population, but I think I would condition it in a very small way. In North Las Vegas, we do have a decent homeless issue, and a lot of our homeless congregate down in the central business district, down by the casinos, down off Lake Mead, down off Las Vegas Boulevard. While I find it inherently almost unfair that these people would be arrested and then receive up to 6 months in jail for just being homeless. I think there is a balance there where if it's not just homelessness, but you now have a person that is bothering people at gas stations, coming up and soliciting money when people are like, please leave me alone, I just want to go to the gas station, or walking in and then accompanying with stealing. I think that is a bigger issue there. However, I can refer to specifically to make my point, I actually recently had a homeless case where the person that was homeless who was arrested, they found them out in the desert and they were sleeping on a mattress. And it was a citizen that just drove by and said, that's like a public blight. I don't like that. The police responded. They ended up arresting him for vagrancy. They put him in jail. And to me, I think that is a complete waste of public resources. So if the homelessness connects to another crime that affects the city life, I understand it, but just homelessness by itself, I don't agree with it. And I think the diversionary programs there, especially in our court, I'm sorry to run over, can't address that.
Can you please, Cindy Lake, Veterans in Politics, describe the administrative powers of Muni judges and in multi-judge courts as per NRS Chapter 5, such as assigning cases or using pro tem judges? What ethical or operational restrictions ensure these courts conform to court practices? Judge, please.
NRS Chapter 5 specifies the municipal courts and lays out the powers. I think it works hand in hand with our city charter and our city ordinances on how they fulfill it. So specifically, our courts handle any misdemeanor offense that happens within the incorporated section of North Las Vegas. Additionally, municipal courts can also address bonds, taxes, levies, and also recovering city property up to the value of $2,500. It also specifies that we can create the diversionary courts. And if the diversionary courts we don't have, and they have downtown or in justice court, we're allowed to transfer those cases. We're also allowed to transfer the cases in the administrative justice. So if it could be held and heard better, there could be a conflict of interest, things like that, we can transfer the cases out. In our courts, Judge Ketter is designated as the chief judge. So he handles along with our court administrator, he handles the operation of our court itself. He assigns the cases, he handles the administration, the day-to-day hours, things like that. So that also conforms with it. Additionally, the way that we pick our pro tems is consistent with NRS Chapter 5. They have to live in our city, they have to be a qualified elector, they have to be an attorney, and they have to be in good standing. We also have a screening process for judge pro tems along with what are called senior judges. Sometimes we have senior judges that have retired that come back.
Chris on this topic. He has been a sitting judge for 4 months, 3 months. However, this is something I need to look into, and I can learn it, and I will learn it when needed.
Real quick, we're going to go to 60-second answers just so we can get through the last three panelists. So a little bit more brevity. Carry on with your questions.
David Farrakhan with the Armed Forces Chamber. What factors should a judge consider when determining bail or release conditions? We'll start with you, Judge.
We have the Supreme Court, the Nevada Supreme Court, that basically defines out the factors that must be considered. Specifically, we have to look at no idea of a standard bail, but we have to individually address each criminal defendant. We have to find out whether or not they have the ability to flee. What kind of criminal offense is it? What kind of criminal history do they have? And the facts and circumstances that are there. Is this a violent offense? Is it a second offense? Things like that. Then we hear argument from both the prosecutor and from the defense attorney or the public attorney once they're put on the case to specifically address what kind of threat that person can be if released. And is there a need for bail? So you would take different factors. You could have 4 or 5 different domestic violence cases, but you'd have to look at each of the factors. Does that person have access to weapons? Was it a violent crime? Is that victim in court now saying, I really don't wish to do anything? Things like that all play a factor in the determination of bail. And I think they have to be addressed case by case, issue by issue.
There are many factors to consider when addressing bail. Specifically, you can look at the criminal history of a defendant. You can look at the allegations of the case. You can look at the provability of a case. You can look at the constitutional issues. You can look at the mitigating circumstances that may include whether or not he or she's a flight risk or a threat to the community, which can be whether or not he or she's going to school, whether or not they have transportation, whether or not they have ties to the community, meaning family or friends, or owns a house, or things like that, whether or not they're working or employed. But also, if I didn't say it already, the criminal history of a defendant as well. All those need to be tailored to the least restrictive means to ensure that he or she will return to court and that they're not a threat to the community.
What steps would you take to ensure litigants who represent themselves understand the process?
I believe we spoke on this a little bit earlier. If a defendant wants to, or litigant wants to represent him or herself, a judge would have to do a phoretic canvas to make sure that this person knows what they are getting into. They have to do it knowingly, freely, and voluntarily, right? So they would ask all these questions about the charges. Have they had experience going to trial before? They'd have to ask, do you know what an opening statement is? Do you know what a closing statement is? Do you know what jury instructions are? Do you know you're not going to have any leniency just because you're representing yourself? So you have to ask, I think there's a lot of questions you have to ask. You just have to make sure that this litigant knows what they're doing. As far as giving guidance, I do believe the judge is limited in what guidance can be given. And if there's any hesitancy, you can also appoint standby counsel to help.
To keep it very short, I agree with Alex. But beyond that, beyond the determination, as Alex laid out, whether or not that person is capable of representing themselves, I think the appointment of a public attorney, either a shadow counsel, as an advisor, whatever you like to call them, is paramount. I think that protects that person's rights, so that person, if they get trapped or if they feel trapped by the prosecutor or they get confused on the process, even after we've warned them as the court, hey, you're not getting any breaks, or we're going to hold you the same accountability that a prosecutor is or any other defense attorney. I think having that public attorney there is essential. Additionally, and going beyond that, I think when you actually get to plea agreements and they want to enter in pleas, as Alex mentioned before, and I'll state again, I think you have to have a very lengthy canvas. I think people have to understand what they're entering into. And like I said before, I've appeared in front of many judges that are just like, okay, you understand, you're freely and voluntarily entering this? Okay, goodbye. I think an extremely extensive canvas is needed.
Joanna, we'll pick up the next series of questions with the next candidates with you as we've run out of time. I'm going to give each of you now 60 seconds to shore things up for yourself, talk about yourself, let the viewers know where to find out more information about you, contact you, something like that. So carry on, Alex.
So you can find me on all social media, Facebook and Instagram at Alex Henry for Judge. You can also go to the website, alexhenryforjudge.com. And I do believe that I am in the best position to be a fair judge that can hold defendants accountable and restore the community to whole. That is something that is needed in North Las Vegas, and that is something that I want to ensure happens. I do believe my training experience as an attorney and as a licensed social worker gives me the background to have open communications, to hear everybody's side of an issue, and to also hold people accountable. Thank you.
First, I would just like to thank this panel for having us in. I know a lot of viewers out there watch, and we have an electorate that needs to know who they're voting for. That being said, as I stated before, I was a 26-year police officer with the city of North Las Vegas, 20-year attorney. I practiced in family law, employment law, did criminal defense and criminal prosecution. So I come with a very varied view in the court. And I think that pays off. When I see criminal defendants that come before me that don't understand their rights, don't understand the ramifications that could happen by them entering pleas, I think I come in there with a different perspective that a lot of other judges didn't. Additionally, I've been committed to this community. I worked in this community. I've lived in this community my entire life. As I said, worked on the police department for 26 years. And on top of that, I've stayed involved with the community. And I think it's very representative of myself that I have the entire support of our current city council and our current mayor. Thank you.
All right. With that, I'd like to thank our sponsoring organizations, Veterans in Politics International, Nevada Veterans Association, and the Armed Forces Chamber USA, as well as our sponsors, Judge Jacob Reynolds, Clark County District Court Department 29, Judge Mary Perry, Clark County District Court Family Division Department P, Judge Veronica Barisic, Clark County District Court Department 5, Danielle A. Taramu, candidate for Clark County District Court Judge Department 28, and Amanda Pellizzari, Las Vegas Municipal Court Department 1. Thank you very much.